You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, as you know, we put Ghana first. My guest, still in the studio and joining us via Zoom now, is Oliver Mausi Baka Vomao. He's researcher, Corpus Christi College, University of Cambridge, and Chief Technical Advisor, University of Ghana, School of Law's Democratic Vigilance Project. Gabia Saracherdako is here, and Sami Jemfie also here. Oliver, thank you for your time.
Thank you, Compel. I'm happy to join the conversation.
Great. Now let's go to the Supreme Court. We'll be right back.
The Supreme Court, in its ruling, framed the issue before it for determination as whether or not respondents can be compelled to give evidence. The court held that witness statements do not constitute evidence until the witness enters the box and takes the oath to indicate reliance on it. This is against the background that Mr. Chachuchikata had argued that by filing a witness statement, the EC chairperson had elected to give testimony. Moreover, the Supreme Court, in its unanimous ruling, averred that the positions in affidavits in opposition to interrogatories cannot make respondents compellable. The EC, in its affidavit in opposition to an earlier demand by the petitioner to serve interrogatories, stated that those questions could be asked during cross-examination.
The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Law's case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Law's case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are mandated to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
According to the court, the petitioner's case should stand or fail based on the strength of his case and not the weakness of case of the respondents, if at all. So the Supreme Court is expected to sit again on the 18th of February 2021. This will be after all the parties involved in this election petition have filed their final written addresses. And these final written addresses is sort of the conclusion of the case for all the parties to present their thoughts to the court before the court sets a date to render judgment.
That's Joy News' Kweku Asante reporting from the Supreme Court. Now, Oliver, a day before the ruling, the same Supreme Court, differently constituted, 5 justices, led by, so to speak, as in the decision that was rendered, led by the judge that you and I are so familiar with and can say he's a master of the rules, Justice Amadou Tanko, delivered a decision which you use that decision to predict, because 4 of the judges on the petition were in that case, and you predicted that nothing different will happen. From all accounts, the courts or the judges have stuck to, if you like, the status quo, correct?
You're absolutely
correct. I think, but also I wanted to contextualize two things. I think one of the reasons why this issue has been difficult to resolve and perhaps so divisive is that it's a difficult case, as the phrase is used and understood in law. And it is in the nature of difficult cases that they do not arouse ready-made answers in the statutes or from jurisprudence. So naturally, all parties are free in the proper mode of legal reasoning to solicit and perhaps even stretch, shifting and sometimes cross-purpose public policy arguments or prayers to try to buttress their preferred responses. Now, in the conversation about this, we've had, on one hand, some people pitting common sense and good governance against established or the integrity of the legal system itself. As far as I understand it, and perhaps we can get a bit more into this, I do think that the decision is appropriate, but I also understand the compelling arguments that have been made for why the Supreme Court should have looked to take a different position. So to speak a bit more about this, if you'd want me to.
Right. So you have even criticized me, and I like the academic enterprise that we were engaged in. That you can see clearly that they gave us a plethora of precedents. That is to say, this is the position of the law. It has been like this. Why should it be changed because of some difference of parties? The Latin expression that is translated literally, let justice be done, even if the heavens come down, should not be a respecter of who the party is. Is that not so?
No, I mean, you're absolutely spot on that. I mean, coming into Thursday, I took the position that it was important that the court preserve the sanctity of the defendant's right to defend their case, however best they see it, And while we may have legitimate reason to gripe over the EC's dismissiveness of conduct, for me, certainly the answer cannot be that whenever a respondent, even in an election petition, submits a witness statement, they are bound to mount the witness box, or that they cannot withdraw from testifying if they deem that as the best way to prosecute their defense. And my point is, why upend our legal system especially when there's already a pathway under the rules for how the impacts, if you prefer, can be resolved. So as someone who generally believes in that the exercise of judicial power must be restrained, it will be arguing against myself to advocate sending the court on some ill-advised expedition without first looking where it steps and without regard for the kind of echo the decision could have in the future, and say that it should defect to some inquisitorial reasoning in order to compel the EC chairperson to take the stand.
Some would say in connection with that, apart from it, quote unquote, not making legal sense, does it even make common sense for a court to compel a party or a witness in a case to adduce evidence when they decline to do so? Because, like we know, in the ordinary scheme of things, if you went to court as a plaintiff and the other party decided that they will not adduce evidence, you will jubilate because you can be sure that you have an advantage over them. Why is it different in this case? That the party who says, I don't want to get in the box, the other party who must take advantage is not happy, and we are criticizing the court.
So this is where I think perhaps there's room for nuance. I generally believe that it would be wrong on the court to compel the witness or a respondent to defend a case in a different manner that the court seems is the best way to defend the matter. But in this case, I think there's some persuasion in people's argument that the circumstances in this case are arguably slightly different, in that the witness in repeated affidavits and the second respondent's counsel's arguments in opposition appeared to commit itself to appear as a witness, or the first respondent's counsel, to commit itself to appear as a witness. And in exchange of that commitment, urged the court to refuse the interrogatories and the inspection of documents. In fact, if you remember the exchange between Her Ladyship Mensa Bonsu and the counsel for the petitioner, the court itself has been caught a bit flat-footed, in that they also kind of expected that some of the questions to be asked on cross-examination. So this was by all accounts a special set of facts And I would not necessarily have been surprised, even though I've taken the position the court was right to take this decision, that I would not have been surprised if the court had insisted on the witness being cross-examined, especially if it took care to distinguish this case without, claiming that this applies in all election petitions by default.
Okay.
And to add a bit more, I also find particularly compelling the alternative argument that has been made by some, including Professor H.K.C. Prempe.
Yeah, I'm going to canvass some of that to you and hear what you have to say. Then I'll come back to the studio here. But when a witness decides or a party decides in the way they have decided, ordinarily, it is to whose advantage?
I think ordinarily, and this is one of the things we as lawyers, and perhaps if I was in the place of the respondent's lawyer, I may not have taken this decision, because as lawyers, we are trained, I think, to put all our best foot forward. We even set out legal arguments ex abundante cautela, but that's in excess of caution, right? So that you are doing the best as the facts would have it to be able to prepare your defense. In order to disarm yourself by refusing to defend the matter takes a level of perhaps arrogance or confidence in how the court is going to rule ultimately for you to avail yourself of all the defenses possible. So I think that ordinarily it is in the petitioner's benefit that the respondent is refusing to defend their case.
The court cautioned the respondents, if you heard in the judgment, that once they are not coming in, they will not compel them. But they must be minded that they will weigh the evidence as it is before them. We have heard about the story of putting in her witness statement as hearsay evidence. Briefly tell us, what's the value of hearsay evidence?
So, thank you for that question.
I think one of the interesting questions here that the rules doesn't say clearly is that even if you put in hearsay evidence, does it, does it nullify the objections to hearsay evidence that already exist under the Evidence Act? So the process for you to tender in the witness statement as hearsay evidence must also comply with the limitations that exist under the Evidence Act for when hearsay statements can be admissible. And I think that conflict itself is not properly resolved. So even when the statement is brought in as is being canvassed as hearsay evidence, I think the petitioner continues to bear a burden in demonstrating what about the statement is helpful to its case and particularly relevant in advising the court on the issues that have been set down for judgment.
I asked the question, what's the value, or as you lawyers say, probative value of hearsay evidence?
So generally, hearsay evidence, as you know, is not admissible on subject to
certain exceptions, right? And so generally, the courts are always very suspicious of hearsay evidence, especially if the person is available to speak to them. But in this particular case, you should be mindful that the process by which the petitioner may put this as hearsay evidence might entail another application for them to call the EC chair as an adverse witness to be cross-examined in respect of that statement. So I don't think that the ordinary circumstances and the way in which we treat hearsay evidence suspiciously may necessarily apply in this case.
All right. Now, listen to Dr. Arthur Kennedy. He wrote this from his base in the U.S., and he titled it, Unjust Ruling by the Supreme Court. He's fascinated by all the precedents that they refer to, and then he comes to say, the court respectfully was too focused on law rather than justice. Yeah. Then, at a point, he comes to say, the court would have done a great service to Ghana if it had found a way to get the EC chair on the stand under oath to explain to Ghanaians what happened and why. If Chachu Chikata had the opportunity to cross-examine him. He gives a number of examples and then come to conclude that our democracy, our electoral commission, the Supreme Court, and our president have been harmed by a ruling that suggests, unfortunately, that the EC has something to hide and the courts and the victorious president wants to help in hiding it. Now, this, you will say, is the general view of the section of the public who think this is wrong. H. Kwesi Prempeh writes, Professor H. Kwesi Prempeh has taught law, has taught constitutional law for many years, has helped countries draft their constitutions and so on and so forth. He says, no progress in the law or in society generally has ever come from those who insist on, quote, a blind, often self-interested allegiance to the status quo in the name of custom, tradition, or precedent. You cannot pretend to believe that the law, whether common law or the Constitution, is a living organism, yet insist on an uncritical fidelity. Note that.
Yeah.
An uncritical fidelity to precedent, unquote. Especially one laden with technicality, even when the times and context and values have presumably changed or don't apply. He's got a few things to say and why he thinks the court has lost an opportunity, particularly in this matter. What's your commentary on the school that I use these two intellectuals to represent?
So thank you again for this. I want to take the time to also, again, take a step back and say why the views they're expressing are legitimate. The call for the chairperson of the EC to take the witness box and be cross-examined needs proper examination. The majority of Ghanaians have gone through an election process where their faith in the EC's competence has been shaken. There's been legitimate questions of process and disenfranchisement, which I believe raise such serious issues that make the EC vulnerable to a petition for their removal under the Constitution. I have, for instance, taken the position that the disenfranchisement of the people of Santrofi, Akpafu, Lipe, and Lolobi amounts in no uncertain terms to an administrative or regulatory coup d'etat that effectively overthrows the Fourth Republican Constitution insofar as it relates to Parliament. For this reason, I now refer to this Parliament, which continues to sit without a significant part of the country being represented, as the first post-Fourth Republican Parliament rather than the Eighth Parliament. So to call it, as I understand, the Eighth Parliament involves a level of intellectual dishonesty that I'm not inclined to participate in. So I think that a lot of people were hoping that cross-examining the EC chair on live television will bring the catharsis we all need, a sort of truth and reconciliation process which allows this nation to chart a path forward with an honest sense of what truly transpired in the last election petition. So if I look at what H. Kwesi Prempeh and the others are saying, and the way he presents the option, if the arguments against it, he says, is that somehow lowering the evidentiary bar for the petitioner would encourage frivolous presidential election petitions, then so what? So what if we have, he says, frivolous presidential election petitions every 4 years? It's a better outcome for our democracy. And I cannot disagree with this view. In fact, I endorse it.
Okay.
What we disagree, however, is whether this initiative must come from the judicial branch or the legislature. I think insofar as the Parliament, through Section 14 of the Evidence Decree or Act, has expressed a view that in such matters the burden of persuasion should remain with the petitioner, I think the invitation to redefine law should emanate from Parliament rather than the bench. And as someone who is very distrustful of the bench and its tendency to exercise undemocratic powers, I think a private member bill will be the best way forward too, rather than ask the bench to engage in lawmaking.
All right. Holding on there. And Gabi, this school of thought that I present, they eventually come to the point and they give you very sound arguments about how we know our Supreme Court has a law-making function. It actually makes the law or the rules at certain points. And they suggest that this is a circumstance where the evidence suggests it could have made an exception for the independent constitutional body or a public entity like the Electoral Commission to come into the box, and it would not have unnecessarily opened, if you like, opened the floodgates in this circumstance. It lost a rare opportunity to do so. What do you say?
pursuit of justice should not be sacrificed for an unjust cause. I think let's get that clear. Now, H.K. Pempe talks about precedent. The Supreme Court did not even need to talk about precedent. They should have just even stuck to the rules. Now, it's important that...
That Supreme Court is the creator of precedents.
But I'm coming to the point that they didn't even have to even add precedent to it, because the rules are very clear. And the lawyers cannot say that they took the case of their clients to court, oblivious of the rules. Now, if you look at I'm looking at CI 87, okay? 3E1, okay? If you read it, it tells you about if a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement. So there are two legs to it. First, you have served a witness statement, and then you elect to rely on it. You must elect to rely on it, okay? So you can't say, now this is just going by the rules, forget about even precedent. And are they telling us, inviting the court to forget about the rules?
Not forget about the rules.
But to do what?
Is the court incapable? I think that's the question.
No, but
is the court incapable or unable to create a precedent here?
For what purpose?
Looking at the circumstances.
No, I mean, what are the circumstances? The circumstances are that
this was a witness who was naturally expected, had announced that it will get in the box. No. The thing is that you go to that we shouldn't forget why we are in court, and that's why they talk about the Electoral Commission is accountable to the country. The day you declare the results, that's when you account for your work. And if people have issues with your work, they go to court. And when they come to court, the onus is on them to show that you did not do your work properly. Okay? It's really that simple. And perhaps it may be useful if I read to you what Atuguba said. I think it's in page 63 or so. In the decision. Gabi is opening the 2013 Supreme Court of Ghana Law Report, the special edition, which was dedicated to the 2012-2013 election petition. So, which paragraph, page are you taking us?
Atuguba will be page 1.
You can actually summarize without reading.
Let me just summarize.
Okay.
I think it's important. I actually have it here.
Okay.
But what Atuguba did, essentially, was that he went straight to the Constitution. Okay? And I'll read to you what he said. He read the declaration, and it says that this is talking about the Constitution, Article 63. He emphasized the presumptive effect of the instrument of declaration of presidential results in Article 63(9) of the 1990 Constitution. And it reads, an instrument which is executed under the hand of the chairperson of the Electoral Commission and under the seal of the Commission, and states that person named in the instrument was declared elected as the President of Ghana, at the election of the President shall be prima facie evidence that the person named as so declared. What does that mean? It means that if you're going to challenge the declaration, because it is presumed that the declaration was what? Correct. You have to what? Bring evidence to court to make that case. Is that clear? Okay.
In that respect,
good.
Will it be fair that they were denied the discovery in respect of Form 13, which they don't have?
I can take you back to 2013. Okay. When similar discoveries were made. I mean, when our 10th application.
Yeah, we are familiar with the issue.
Good. And even when you read that decision, you know what the court said? The court said that they had all the documents, including the collation sheets. Bear in mind, even at that time, they were not entitled to the collation sheets. Okay? They were not entitled to the collation, but the court even said that they had the collation sheets. Now, when you look at all that is being said and done about justice and the rest of it, the key point is that in order to have justice, in a sense that you come to court and say that these are the reliefs I'm looking for. And what are the reliefs that they are looking for? They are looking to say that in the declaration of December 9, Akufo-Addo did not go beyond the 50% required. And then the question is, so if he did not go beyond the 50% required, what did he get? What numbers are you presenting to court to say that, of course, the results as declared were invalid? And that's really the key point. If you remember, back, I believe, on 22nd January, the respondents raised a preliminary objection. And the whole preliminary objection was that they have not made a cause of action, so that the case must be thrown out. What did the court say?
It will include that in its judgment.
Precisely. Now, it gives you an indication that right from the beginning, the respondents, and that's what Chachuchi Carter should have taken his cue from, that right from the word go, after you presented your case, the respondents knew that you had not made your case. Because, you see, when you look at, the evidence is all before us, okay? They brought exhibits. And now here we are talking about a margin of over 500,000 votes. You are saying that the declaration was wrong, in a sense that the over 50% required, they did not meet that threshold. And then when we look at the numbers, because it's all about numbers. You can speak all the English you want, you can quote all the laws you want, you can focus on all the precedents you want. The bottom line is this: do you have enough numbers to challenge the declaration made on December 9? It's really, it is that simple. So then we look at the exhibits, and the exhibits are quite clear. What did they present to court? They presented less than 5,000 votes.
Okay.
Now, please, it's important, you know, and that's why I think we waste too much time trying to talk law, about justice, about law.
For now, let's keep to the decision that is being examined.
But I'm saying that when we miss the point, that's when we get into who is right and who is wrong. You've come to court to challenge a declaration. The Constitution is absolutely clear that once a candidate gets more than 50%, that person is declared the winner of the election. You have gone to challenge it. Yet, in your evidence, the evidence that you presented to court, when we counted the less than 5,000 votes that you are challenging, forget about it. He calls it what? Sample details. You think it's an opinion poll? It's an opinion poll that you sample. But when opinion polls are done before an election,
right.
But when you come to court,
I think you've made a point.
Yeah.
Now let's look at it this way. You refer us, for example, to the discoveries, interrogatories,
yes,
and talk about how even in this, that's what led you to opening the 2013 Supreme Court of Ghana Law report. Yeah. The court then unanimously, so you are saying they stuck to the law, which is section 166, I think, of the Evidence Act, and said, well, if you already have copies, and if the copies you have, they are duplicates, duplicates are accepted in the same way as originals. But in that decision, when they finished, and they finished the case and they were going to write their judgments, here Justice Doshie, who was part of those who gave the decision, as in unanimous decision, 9-0. He said, the production of the pink sheets would have solved the problem. This is the pink sheets they denied. When Nana Akufo-Addo, Bawumia, and Jacob Echevilamte were asking the EC to bring them. Yeah. They said, you have copies already. We stay there. But when they got to the judgment, Doche found himself in a difficulty and now seemed to criticize himself and his colleagues. He says the original pink sheets would have solved the problem. Now, he said he could not rely on the pink sheets that they had. And he says these pink sheets cannot be relied upon. He says some of them, the writings on the pink sheets are clearly ineligible in some of the columns on the entry sheet. Apart from the results, sometimes the results are also not clear. Then you had Akoto Banfo, Vida Akoto Banfo, who also voted for the unanimous to reject it. He came back later also saying the entries on the pink sheets being unreliable in determining the petitioner's claim based on overvoting, and they spoke about a lot of things. I don't want to bore us much, but let me read this portion to you. He said that in the light of the above stated adverse comments given by Doche and Vida Akoto Banfo, in the final judgment of the Supreme Court to the effect that some of the entries on the pink sheets created serious doubts about the authenticity of entries on the pink sheet. Owing to the mistakes, the pink sheets were manifestly unreliable as a basis establishing the phenomenon of voting and so on and so forth. The second respondent ought to have been ordered to produce the originals of the collated sheets, the pink sheets. So this is a court that took a decision. Then some of them now regret it. Now you say that they stuck to the law. What will you say to the question? For example, in the 2013 petition, the Constitution is clear that presiding officers should sign the pink sheets. In the circumstances where they didn't sign, the court said, we will not interpret that to mean the pink sheets are invalid. We should rather be punishing the officer and not the voter. Why? Because they took circumstances into consideration, that the voting was counted in the public and so on and so forth. Why can't they take circumstances in this situation of what Jean Mensa had, every events that she wanted to do, to say,
Samson,
on this one, you go in and testify?
Samson, the circumstances are very different, and I'll explain why. In 2013, first of all, the John Mahama won by 5,574,761 votes, okay? And that was 50.7%. Akufo-Addo got, I believe, 5,248,898 votes. That was 47.74%. In order for John Mahama to drop below the 50% threshold, you needed to take away 77,131 votes from him. Just that, okay? The difference between Akufo-Addo and John Mahama was 325,863. What was the evidence presented before the court? The petitioners said that there were over 2 million duplicate pink sheets, which then goes to the heart of what? Even the authenticity. Is that not the case? Okay? And then they spoke about polling stations that they were not aware of. Okay? That also goes to the credibility or validity of the results from those areas. They spoke about overvoting in 1,722 polling stations. Okay? They spoke about voting without biometric registration.
Verification.
Verification, sorry. And when you look at all this, the sum total, even when you take overvoting alone, that would have dropped John Mahama down. When you take voting without biometric registration on its own, that would have dropped him below the 50%. When you take voting without the presiding officer's signature, which is a constitutional requirement, that would have dropped him down. Forget about even the duplicate sheets. So there were all these issues put.
In fact, a couple of the judges found so and ruled for a rerun.
Precisely.
Right.
Now, so on the face of it, if the Electoral Commission at the time was to elect to say that, look, I am not going to go into the witness box, that would have been suicidal. But in this case, and that's why I'm saying that let's not...
Please proceed to make the difference you're making. Yeah, it's important. But in
this case, you are talking about less than 5,000 votes that you are challenging. That's all it is.
Let me bring
look, no, let me finish. Let me just make this point. So when, assuming Jean Mensa goes into the box, will her testimony add to John Mahama's votes or take away from Akufo-Addo's votes?
Okay.
And what
can you answer Gabi's question?
Thank you very much. I think it's important for me to correct this misrepresentation about what the case of the petitioner before the Supreme Court is.
You should read the ground and the release.
This election petition is not a challenge of 5,000 votes. That clearly is misconceived. That opinion is misconceived, clearly. This petition is a challenge of the constitutionality and the validity of the declaration of the returning officer for the 2020 presidential election, Mrs. Jean Mensa. And that challenge is based on the fact that per the terms of her own declaration, per the figures, or if you like, the data in her own declaration, the declared winner, candidate Akufo-Addo, did not attain more than 50% of the total valid votes. Hence, was not validly elected. He didn't win because per your own declaration and the figures contained in that declaration, we are saying that candidate Akufo-Addo did not win. And we have said so because in Jean Mensa's own declaration, and anyone watching me can take a calculator. This is a declaration which is available on YouTube. We all watched it on television.
That's excellent.
It's been played in court. So I'm building a point.
So you have said so.
No, I'm building a point.
And what you have said is in the body of your case.
No, so let me demonstrate that.
Now, why do you need her in the box?
Yes, I will answer that. But certain misrepresentations have been made that needs to be clarified. Because in that declaration, Jean Mensa said that candidate Akufo-Addo obtained 6,730,413 votes. And that the total valid votes for that election was 30,434,574. And that candidate Akufo-Addo, by virtue of that, had a percentage of 51.595. Now you can do this calculation. Divide 6,730,413 by 13,434,574 and multiply it by 100. You will get 50.098 and not 51.595 as declared by Jean Mensa. And this was based on just 274 constituencies minus Techiman South. Then the returning officer, Jean Mensa, proceeds in her declaration to say that even though I don't have the results of Techiman South, I will proceed to make my declaration because even if all the votes in Techiman South were added to the votes of the candidate who had placed second, candidate Mahama, the outcome will not change, meaning that candidate Akufo-Addo will still cross the 50% threshold. Now, what is the total number of votes in Techiman South? We know that 128,018 votes, 128018. If you add 128018 to the total valid votes declared by Jean Mensa, which is 13,434,574, you get 13,562,592. And candidate Akufo-Addo's votes remains constant at 6,730,413 based on her own declaration.
Have you worked this mathematics in your case?
It's been done. But yes,
wait,
we've done it both in our pleadings.
Do you remember same questions posed to Esiedun Ketia and Professor White about the figures?
Yes.
And do you remember the answers?
Yes, I remember the answers, very explicit. From paragraph 6 to paragraph 17 of our petition, these calculations are set out clearly.
If they are set out clearly, Your case is made without her getting in the box.
So I will come to that. But it is important for those who have not had the benefit to look at those documents to hear what I have to say in reaction to what Gabi has said.
I think you have done sufficiently enough.
So the conclusion I'm making here is that if you added Techiman South, the votes in Techiman South, to the votes of candidate Mahama, candidate Akufo-Addo drops to 49.625. And this evidence is contained in Exhibit A, which is the video of the declaration which has been played in court and which forms part of the evidence before the court. And this is the only declaration we have had.
The reason I was asking you,
if you allow me to flow, I will come to that.
No, it's not about flowing. Let's ask the questions.
Okay.
If you followed Esiedun Ketia, they were asked the question, have you done your own independent calculation, like you have just done here publicly with so much ease?
Yeah.
What was his response?
That was not a question Esiedun Ketia was asked. Esiedun Ketia was asked by Justice Apau that, have you done your own collation? What are your figures? That is different from the
exactly what I have said.
No, that is not exactly this. And let me show you the difference. What I have done here is a calculation based on Jean Mensa's own figures.
Okay.
And we have said that to the extent that we are in court challenging the constitutionality and validity of the declaration of Jean Mensa, our figures, and for that matter, the figures of any political party, is completely irrelevant to the issue.
Right.
What is relevance?
In the next 4 minutes, tell us why it must take Jean Mensa to get in the box for you to make your case.
So the first point I have made here is that to the extent that per Jean Mensa's own declarations and the figures contained therein, candidate Akufo-Addo doesn't cross the 50% threshold. And to the extent that Jean Mensa herself and both respondents in the case admit that this declaration is in error, and to the extent that this is the only declaration that has been made since the 7th of December when we went for the polls, and that the wrong declaration has neither been amended nor revoked, then in effect, the respondents have agreed with the case of the petitioner that the declaration, the enactment of same, which is CI 135, and the Gazette of same are all wrong and should be annulled.
And the effect is a rerun. The legal effect is a rerun.
I don't know why anybody will even suggest that the petition has not made out this case. Okay. Now, the second point I have made is that the issue of what is your figure is something you know. Article 64(1) is clear that any citizen can challenge the validity of a presidential election, right? And so if any citizen had gone to the Supreme Court to challenge the validity of this election, will we be asking that citizen?
CI 99 appears to have changed that.
Clearly, that will be unconstitutional, but that is a subject for another day. Now, you ask the question, why must Jean Mensa enter the box?
Since
Gabi spoke about rules, you understand? And let me make the point quickly, that the issue you raised, 5,000 votes pardon, is just one issue in the petition. One. That is not the main issue in the
question I've asked you is still pending. In 2 minutes,
hold on.
I take a break.
What are the other?
No, hold on. Sam said he had ample time.
In 2 minutes, I'll take a break.
I think I'm being stampeded.
It's not about how much time anybody has had. You guys, you like doing that. Please go ahead. Go ahead.
Sam said the point I'm making is that, yes, it is about the rules and what the rules allow. Every respondent is entitled to say that I will not testify. We all know that. Okay? Why hasn't the petitioner sought to compel the witness for the second respondent, Peter McMenu, to testify? Why? Because we are not just interested in compelling people to testify. We are saying that even though the first respondent has a right to elect not to testify, the court should not allow them to do so because, number one, they have already elected to testify and therefore are stopped from changing or resiling from that position without any reasonable grounds or justification. We all know about the doctrine of estoppel, that even though you are entitled to a right, that doctrine will prevent you from asserting that right if by your previous actions, words, you have agreed to do otherwise. And we are saying that per her affidavits before the court, I will not even talk about the witness statement. Her affidavits, evidence under oath before the court.
Evidence under oath for applications,
yes,
not the case.
But it is still part of the record of proceedings before the court.
But that matter is dealt with, and the court is functus officio on it.
No,
the court has no business on it. It's gone.
No. So, for example, are you saying that if a witness enters into the box and gives evidence under cross-examination that contradicts evidence the person had already given in an affidavit in an interlocutory matter, saying
cross-examination
out by counsel,
cross-examination is at large. Cross-examination is at large. But you cannot use that affidavit on the main suit.
As lawyers, we can have different opinions, but I think as a panelist, you let me make the point we are making, which is the case of the petitioner, is that in your affidavits before the court, you have told the court.
How many?
That 2, in this case. You've told the court that don't allow the petitioner to ask me these 12 questions. You remember when we filed for the application for leave to serve interrogatories on it? Because I will be available for cross-examination. And the petitioner can solicit these answers from me.
Was that the only reason?
Therefore, by your own words, the Bible says, by your own words, you shall be justified or condemned. By your own words, by your own conduct, you have already elected or intimated to the court that you will testify. And therefore, you are bound, you are stopped from resilient from that position.
Do you remember, however, that in the same affidavit, after she has said these things, she comes to say, there's really no point. I have already made them available to you. There's really no point. And all that you are,
but they agree that we don't have from 30, and you yourself agree that
yes, they agree that you don't have.
But the bottom line is that that witness, that is the difference between Jean Mensa and Peter McMahon, one of the reasons.
Okay.
So she had elected, number 2. We have also said that this witness is not an ordinary witness. Her testimony will not undermine or affect our case in any way. But given the fact that she is the returning officer for this election, which is in dispute, and that this petition revolves around her conduct, whether it is the declaration she did it, whether it is the enactment she signed it, whether it is the gazette she signed it, and given the fact that she, after her declaration, has come back to tell the nation that, look, I made an error, and subsequent to that, the Electoral Commission has churned out different conflicting figures.
All right, thank you very much. We take a break here.
What I'm saying.
We take a break here. When we return, I'll ask Oliver.
You allow me to conclude.
This attempt.
I think this is.
Please, no, don't do that.
If we
this attempt to get
allow me to conclude.
by subpoena, what are the prospects? We have run out of time. We'll be right back. Yeah, welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And it's brought to you by Bank of Africa, strongest a group and closest a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Duroplus, where Duroplus goes, water flows. Heaven, mosquito spray and coil. Pleasant on humans, tough nightmare on insects and upper foods. It's tasty. DBS Industries, talking about anything roofing, that's where to go. Roberts and Sons Limited Optical Services, your comprehensive eye care provider, service provider. And okay, so Oliver, yes, so I'll come to you. The two of you will end it here. Oliver, now, okay, in case you have just a minute to canvass, having heard the two politicians, of course, they will communicate the law, but communicate it in a manner that, gets to their base. If you have any commentary to make in a minute, then you add on the question of how difficult a hurdle it is to get a subpoena, to first get to reopen his case, as in Chachu, and then, or let me say the petitioner, and then get a subpoena. And there are people who are asking questions. You can put the witness in the box. Their answer can be no, no, no. And you can't force any other thing from them. What's the point? Yes?
So thank you for this. I think I want to say that, the petitioner has already made an indication that Section 72 application to call the EC chair as an adverse witness will subsequently be made. And it seems to me that when that application is made, the court may find it somewhat persuasive, this argument that a legitimate expectation was created that Jean Mensa will testify, which is what Sami referred to as the estoppel argument. Because if you think about it carefully, if the petitioner had sought to invoke Section 72 before closing its case, which I'm surprised they didn't play that card, it would have been very likely that the court would have refused the exercise of discretion on the basis that the witness has already committed to appear in court.
Yeah.
In fact, the first respondents' counsel may have argued the same thing. So I think this estoppel point should not be easily dismissed. However, on the other hand, I agree that the petitioner has a real hurdle to cross in getting the court to exercise the discretion to entertain the application, because I think they will struggle to find the language to justify why her appearance is necessary.
They have said in the affidavit, we can't discuss it, but they have said in the affidavit the points that Sami has canvassed. She had already indicated she will be there, she'll be available. Don't force me to do interrogatories, all of that. I will come. Then suddenly you swerve them.
You're playing tricks on the court.
So I think that there are two issues here. That point has to be separate from what is she coming to say when she's on the stand.
All right.
And that is a different evidentiary burden that you must cross.
Okay.
And I think that in appealing to the court's discretion to call the EC chair as an adverse witness, the petitioners must tell us clearly what evidence at all it is seeking from the EC chair. And if the court is minded to side with them, I for one would want to see on what basis they justify why she needs to appear in the court. That we don't have clearly.
All right. Thank you. Yes, so Sami, yeah.
The point I was making is that we all...
What happens if you don't get the subpoena? That's my last question to you. What happens if you don't get to reopen and you don't get the subpoena?
We are confident that we will get. But even if we don't get, we don't think that our case will be undermined in any way.
From the indication of the court, having said addresses should be brought, it means
no, but
at the end of the road.
For the application for leave to reopen,
yeah,
to subpoena, is Monday.
Okay. So
when we go, I'm sure the directions of the court can be amended by the court if they deem fit.
But
the point I'm making here is that Jean Mensa is not just an ordinary witness in a case of competing in private interest. We are talking about the holder of a constitutional office, the returning officer, whose work is a subject for this, petition.
Right.
So given the fact that she herself has admitted that she has made errors, and given the different inconsistent figures that the EC has churned out, and some figures and documentation that their own counsel has confronted our witnesses with, we think that it is only fair to the over 30 million Ghanaians, and I dare say only fair to Jean Mensa herself, for her to be given an opportunity to explain these issues. Above all, Ghanaians who joined long queues at the risk of losing their lives in the midst of COVID to register and vote deserve to know whether the EC chairperson we have in this country and we are paying is credible, whether he has been candid about her job relative to the declaration of the 2020 presidential election, whether she's truthful and all that. It is only under cross-examination that her feet can be held to the fire of accountability and her credibility can be tested. Why is she running away from accountability? If Dr. Afarijan mounted a witness box in the 2013 election petition case and defended his work, why is Jean Mensa running away if she has nothing to hide? And so I agree with those who constructively say
so
that.
So, Gabi, the question people are asking again,
a golden opportunity
and you understand that while this is being fought in the court, this is a court of law, the public is also important because this is also being to them. The question is, why are you against having the EC subpoena? Because they say they will go and oppose it. What is it? Why are you against it? If bringing her in doesn't change the fact that you have a solid defense, why do you want to oppose it?
Make a serious allegation against the declaration of results and then rely on the person you are suing to come and help your case. It's really that simple. It's really, and if he talks about Afarijan.
We have just a minute.
Okay, Afarijan was in the box when he admitted to mention the wrong figures in declaring the results of 2012. And you know what he said? He said it did not go to the heart of what? Affecting the outcome. Bottom line, you've now come to court. Okay, in 2017, if you remember, Charlotte Osei, in declaring Akufo-Addo as duly elected, said that there were 4 constituencies that the results were not in, and she was not going to add that. You are now adding 128,000 voter population of Techiman South and coming to court that because she made an error in announcing the valid votes count, you should be given a runoff. And because, and she should come, no, please, isn't the plea?
Okay.
And because of this, we are in court. I think it's important that they stop.
So why did you file a submission?
Thank you. Sorry. Thank you.
We have no case.
Thank you.
Thank you,
gentlemen. Thank you very much. Now listen to this.
If you think we have not made out
in H. Kwesi Prempeh's article, and I end with this quote from H. Kwesi Prempeh's article. He asked, can the precedent worshippers tell me what exactly Ghana would lose by a court ruling that says that in the exceptional case of presidential election petition, where the petitioner is able to proffer some evidence that irregularities and illegalities were committed by the Electoral Commission, the onus will fall on the EC, or the EC may be compelled to show that even if the allegations were admitted, the errors or infractions would not affect or change the results.
Ask him not to go beyond CI 87.
Okay, thank you all so very much. My guest, Oliver, unfortunately today again we haven't done
no one is open and shut. I mean, it's clear.
We haven't been able to do the Council of State issue again. We apologize for that. I'm Samson Ladi Anyanini. My guests have been Oliver Mausi Baka Vomawo, Sami Jamfi, and Gabi Asare Ochredako. Have a good afternoon. Tomorrow afternoon, 2 p.m., join me and my guest on the Law Show as we talk about how to protect yourself from office infections of COVID and what the law has to say.